From the look of things, it might seem that Yahaya Bello may not be spending Christmas and New Year festivities at home. In a recent development, Justice Marian Aneni of the Federal Capital Territory High Court, Abuja, has ordered the remand of Yahaya Bello, the immediate past governor of Kogi State, in Kuje Correctional Center pending his bail application. According to Justice Aneni, the bail application was filed on November 22nd before Bello's arraignment on November 27th. The judge stated that a bail application can only be made after a defendant has been arrested, detained, arraigned, or brought before the court.
Well, you can recall that the White Lion, Yahaya Bello, is facing a roaring 110 billion naira laundering charge brought against him by the Economic and Financial Crimes Commission. The judge had earlier refused to grant Bello's bail application, citing that it was filed prematurely. In contrast, Bello's co-defendants, Umar Oricha and Abdul Salami Hudu, were granted 300 million naira bail, each with stringent conditions. The hearing of the case has been adjourned to January 29th and also February 25, and not forgetting to 2025. Well, joining us to actually look at this development, we do have legal practitioner Evans Ufeli, who joins us all the way from Atlanta, Georgia, in the United States of America. And the time seems to be about 2 a.m. Thank you so much for making out time to be here to have this discussion. Though short, but then again, we trust that we would get to the end of the discussion. Let's start off first with the adjourning of Yahaya Bello's request for bail. And also, let's look at the fact that this is a case that could have ended if only he had turned himself in earlier on. But what's your overall look of this case so far, so good?
Well, as at the time he was, is he chased or attempts were made to arrest him by the EFCC, and the subsequent drama that followed. His lawyer had filed certain cases in court to the effect that he cannot be available for interrogation up until he later turned himself in. He turned himself in the first time. The EFCC didn't do anything about that before the last time that he did so. Now he's in the custody of the Kuje prison. Before now, the court had first arraigned him and remanded him at the EFCC custody. Now, upon this next court hearing, wherein his lawyer brought an application for bail, of course, bail, the offense is bailable, okay, but it turned out that the bail application that was before the court was actually filed way ahead before Bello's arrest. I mean, the date in the bail application is on the 22nd, whereas he was arrested on the 26th or thereabouts. So when you look at it, you will discover that what that presupposes is that the bail application had been filed before his arrest. And what it means is that that bail application is incompetent by law. That is what the judge reached out in the case under reference. So it is now left for his lawyers to go and do the needful. And that is to ensure that they bring the appropriate bail, because this case has been adjourned to January. The court is already set for vacation. The options and remedy open to him is that perhaps the lawyers will file a fresh bail application and file another motion to abridge time, and then have the case heard if he has to be granted bail within this year, because the court will still go on vacation from the 18th or 16th or thereabouts. Court will be on vacation. So there's also vacation judges who could attend to the case, I mean the bail application. But the issue on that reference here is that even if all that is fulfilled within time, bail is still at the discretion of the court. Okay, it is lucky that the reason the court gave is just because the bail application was premature, it was filed ahead of time. That's the only reason given. No other reason was given as to whether he could jump bail if he's granted bail and all that. Even though the counsel, Kemi Pinero, SDN, that is prosecuting the matter, had also filed a counter affidavit opposing the bail application on grounds that, the defendants a flight risk and so many issues have been brought. And the conduct so far recorded in the case, the former governor, have a record of not following the issues as they were, not complying to conditions. So we'll look at it and see where this leads. It's a developing story because the case is ongoing and the court is doing its best to ensure that the court have now adjourned for trial in January and then continuation of trial to 2 dates for continuation of trial upon the date for trial.
Okay, thank you very much. We're struggling a bit to hear you. Seems like we're losing the end of your words. So if you can help us with maybe speaking up a little louder, that would help. But thank you for establishing a foundation as to why exactly this bill was denied. And we will wait till the next hearing to find out what the next steps will be. But we can't preempt the court. But typically in situations like this, would you be able to tell us if this is a bailable offense?
The offense is bailable. All offenses are bailable, except perhaps for murder and treason felony, which are also bailable, but it depends on the circumstances surrounding every case. Okay, the case under reference has to do with money laundering and issue of corruption and all that. Is a bailable one. Is one that, but the truth is, even if an offense is bailable, it does not confer a right on you or somebody or absolutely that you must be granted bail. There are exceptions to this thing. If the court is of the view or the opinion that there's a tendency that the defendant may jump bail or that the defendant is a flight risk or have a tendency of proclivity to do wrong when such freedom, when such opportunity is granted to that person, the court can withhold, the exercise of that right by its discretion to so do. Okay, ordinarily, constitutionally, it is a right of the defendant to be entitled to bail based on the case under reference or the alleged offense of the defendant. So
all right.
The court will look at it critically and decide whether or not that exercise of that right will be appropriate for him.